One. So a very good day to you all. Welcome to the Wall Street Blockchain Alliance's Call the Lawyer podcast, episode number 3. Before we start, a little bit of housekeeping rules. Everything that we'll be talking about here is for educational and informational purposes only. Nothing that we're talking about is legal or professional advice. It's our short form podcast. A lot of people have been really enjoying it. And it's my privilege today to welcome our friend and legal working group member, Mr. Jason Gottlieb. Jason, welcome.
Hi, everyone. It's great to be here with you virtually, everyone from his or her own house.
Yep. So tell us about the firm, tell us about your practice, tell us about how you got involved in the kind of blockchain crypto world and how you're stuck with us.
Sure. So I'm a partner and the chair of the regulatory enforcement group at Morrison, Cohen. We're about a 100-lawyer firm in New York City, and because we're kind of mid-size, 100 lawyers is giant for a lot of places in the world, but for New York, we're a little minnow. We tend to focus more on middle market kinds of issues. That is either mid-size issues for giant companies or very large issues for mid-size companies. And because we have this middle market niche, it's really made us pretty uniquely, ideally suited for companies that are serious in the crypto space. They may not have the kind of presence in the market as like Apple or Google or Fortune 500 companies, but they're also out of the startup phase, or they're seriously enough capitalized. They can afford a New York City law firm, but maybe they don't need 50 partners at Skadden working on their case full time. So that's the kind of work that we do at my firm and the kind of client we have. Now, as for myself, I've been long interested in the intersection between technology and litigation and regulatory enforcement. Before I was a lawyer, I worked at an internet company in Japan where I did some technical work and some legal work in the in-house legal department. And over the last year, I've been involved in enforcement actions and litigations in the tech industry, particularly involving high-frequency trading or algorithmic trading, and then, of course, more recently in cryptocurrency issues. We represented one of the first ICO issuers against the SEC when the SEC formed their new cyber unit. So we did that. It was really a groundbreaking case, which we were able to settle, and I think some very interesting things for the industry come out of that settlement. And we've been involved both fighting the SEC and cooperating with the SEC and helping clients who are being investigated by the SEC and working with them in a positive way as well. It's been a very exciting time to be a crypto lawyer over the last few years.
And we've had the privilege of having you panel at, I think it was the last legal working group evening event we were able to do before COVID kind of affected everyone, which was our When the SEC Comes Calling, which was a really great gathering interview as well. So everyone's talking about Telegram. Everyone, you've seen the previous podcast, and we'll absolutely get to Telegram. But there's a lot of other stuff going on in this space. And you had pointed out very specifically something that I think is really important as well, a money laundering case out of the Ninth Circuit specifically related to Bitcoin. And there should be a lot of lessons there for the ecosystem. Can you tell us what happened in that ruling? What was the decision, and why is that impactful for the crypto asset space?
Yeah, definitely. So in this case coming out of the Ninth Circuit, it's a US v. Costanzo. I guess for all the Seinfeld fans out there, it's Costanzo and not Costanza. But if it helps, you can envision George doing money laundering with Bitcoin. The Ninth Circuit upheld a conviction for poor Mr. Costanzo, who was running a Bitcoin to dollars trading service. The interesting thing, there are two interesting things that flagged to me from this case. One is that he was accused of money laundering specifically for trading dollars to Bitcoin. Now, usually there's nothing wrong with trading dollars to Bitcoin for your own account if you want to buy or sell or to hold or to hodl, whatever your terminology is. Absolutely no problem. If you're doing it with a counterparty, you want to buy or sell Bitcoin from someone, usually also no problem. But here it can depend on the motivation. And poor Mr. Costanzo was approached by some federal agents working for the IRS who got wind of him from some so-called darknet websites where he was offering his services. And they said, hey, we would really like to exchange money, cash for Bitcoins. And by the way, we're doing it for our drug running service, and we're involved in black tar heroin. To which Mr. Costanzo said, hey, I don't want to know anything about anything illegal. You keep that to yourself. That's your business, not my business. And then proceeded to exchange all of the cash for Bitcoin. So there are a couple of interesting lessons. One is that one can do money laundering through Bitcoin or other cryptocurrencies just as easily as one can do it through cash. And in fact, the conversion of the crypto to cash or cash to crypto here was part of the money laundering that the IRS was concerned with. The second interesting aspect here is he was accused of money laundering with the belief that it was connected to something illegal. It actually wasn't connected to anything illegal. There was no drug running. There was no black tar heroin. The entire thing was a sting operation from the feds. And as far as I could see in the record before the district court, there was no evidence that Mr. Costanzo ever knew that he was doing something that was tied to something that was actually illegal in terms of the underlying drug allegations. Yeah. It was entirely made up by the federal government. And there's that may sound surprising to people, but there's a long line of cases basically saying that the federal government can do that. If they suspect that you are involved in money laundering or drugs, etc., they can set up a sting. And if they bust you on this sting, then you can be convicted of that. The money laundering statute, interestingly enough, doesn't actually require you to be money laundering for actual illegal activity. It only requires you to be money laundering for something that you believe is illegal activity. Yeah. So if a Fed comes to you and says, hey, will you launder, this money for my drug business? And you say, sure, there doesn't even have to be a drug business. You can still get convicted of money laundering. Okay, so why is this relevant for folks in the crypto space? Well, we hear everyone talk about the importance of know your customer, the importance of anti-money laundering rules and regulations. And this really brings it home, because if you're trading with someone, if you have a trading counterpart that says, oh, by the way, we're doing some drug money over here, that's got to raise red flags. And you can't look the other way. You can't laugh it off. You can't think, haha, yeah, this guy's kidding. He's not a drug lord. Come on, that's ridiculous. Yeah. You have to take this stuff really seriously. And that's why the quickest way to get in trouble, and I don't mean SEC trouble like they're going to shut down your business and you have to pay a fine. I mean like criminal penalties, going to prison trouble. Quickest way to do that, frankly, is money laundering. And companies need to be hyper attentive to who they're doing business with and what their stated purpose of the business is, and how reasonable it is for people to have that belief. Because it doesn't take something as obvious as telling you it's, hey, I'm doing this for black tar heroin. If you have reason to know, that could even be enough.
Yeah. And it's interesting, we have this, a lot of colleagues in technology, for example, particularly coming out of the crypto and blockchain space, there was this almost underlying current of, well, intention or belief don't feed into this. I'm digressing a little bit. We've talked about intention in again, the Telegram case. We can hit on that. But technology people in financial markets, people getting involved in crypto, this intention and belief conversation is critical for them to understand, to your point. And criminal liability is something that is potentially an outcome there. And it's something we're hoping the crypto ecosystem will understand. It's just not enough to say, well, it's not up to me what they do with the Bitcoin or the dollars. It kind of actually is.
It really is. And, there are some violations that are where intention doesn't really matter. Mm-hmm. Telegram is an interesting case because a violation of Section 5 of the 1933 Act, intention shouldn't matter. You sold unregistered securities or you didn't. And if you sold unregistered securities with the absolute best of intention, you thought that you didn't have to, you thought it was okay, it doesn't matter. They were unregistered, and all the ramifications are going to follow. Of course, Judge Castell did deal with intentions, which was an interesting part of his decision in Telegram. But generally, Section 5 is a strict liability statute. You either did or didn't, and what you meant doesn't mean anything. What we see here in the money laundering, that intention can actually matter more than the reality. If someone tells you, I'm doing this for drugs, and you look at him and say, that's absolutely ridiculous, I know for a fact you're not, that's stupid, because you think there's no possible way this person could be in it. If you have reason to believe that they are, even if you're pretty sure that they actually aren't, that's not good enough. So intention matters a lot here.
Yep. So really interesting and really important. Let's pivot a little bit. Some other things that have popped up in the space. Many of our readers and watchers and members have seen these insider trading cases, particularly coming from legislators. Those that sat on committees around COVID-19 and dumped all of their stocks before the markets collapsed, for example. And we won't name who those legislators are, and we suspect that there'll be some.
Right. So we won't name those who also have a connection to the crypto world. We'll leave that aside for now.
Exactly. But there's important lessons and important characteristics and features that come out of those conversations as well, directly as it impacts the crypto asset space, the Bitcoin space, for example. Tell us a little bit about that. Tell us about what insider trading is at a formal level. We have a lot of members across different ecosystems who need to understand insider trading, but also what's the impact of anti-insider trading laws in the crypto space?
Yeah, it's a good question. And it's waiting for the first insider trading. Yeah, I'm still here. You're frozen on the screen, but I can still hear you. Should we wait a minute until we're going again? All right, we're good.
I think we're better now.
Okay, good. So we're still waiting for the first insider trading cases in crypto. But it seems a pretty logical next step once the SEC has determined that virtually all cryptocurrencies other than Bitcoin and ETH, maybe some others like Ripple, but we'll leave those questions aside. Once the SEC has decided that virtually all these are securities, then insider trading in those securities is always a possibility for the SEC to be investigated. So what does it take to be insider trading? I mean, we all have a sort of informal, fuzzy notion of insider trading as being, well, I know insider information, I know stuff other people don't, and I traded on it. But that's not actually what insider trading is. There are a few different theories of insider trading. There is a sort of the true insider information where you are the corporate CEO. You know that your company is going to announce terrible results the next day, so you dump all your stock holdings before those terrible results come out in order to avoid the loss. Or you know that your company is about to announce a merger, so you buy more of the stock, or you tell somebody else to buy more of the stock because it's about to go up on this non-public information. But the theory here actually rests on using information that belongs to someone. It's breaching a duty to keep that information confidential. So the CEO has a duty to her company to keep that confidential. And if they misuse that information, either for her own account or because she tells someone else as a tipper, and that tippee receives the information, knows that it's confidential information, sometimes there has to be a benefit back to the tipper, but that's a complication we can leave to the side for now. If someone trades on information, makes money, or avoids losses, that can constitute insider trading. We talked about some members of Congress. There's actually an insider trading statute called the Stock Act that directly covers members of Congress and certain other governmental officials in information they get in their capacity. Again, I think the theory is kind of the same. This is information they're getting as part of their role in the public trust, and they shouldn't be misusing confidential information for the public trust for their own personal benefits. So that's the general background on it. But how does this apply in the crypto world? Well, it's one thing if you kind of hear rumors on the street and you think, oh, this coin is going to pop, I want to get in on that. Okay, whatever, that's fine. That's just investing. You can do that. But if you hear it from a corporate insider who shouldn't be telling you that information, or if you are the corporate insider and you know that information, then trading in that can be insider trading. So for example, if you know that your crypto company is about to announce some great new development that you think is going to make your token pop in the market, just because it's not traded on the NASDAQ or doesn't mean that you can't be liable for insider trading. So insiders have to be careful, and if you're getting information from an insider, you have to be careful because you could be trading in violation of that duty.
And you can imagine this becoming ever more prevalent and important. We had a conversation at our crypto asset working group this morning around stablecoin adoption, for example, around central bank digital currency, around different projects. As we begin to see tokens begin to be more part of economic activity, the definitions around what's insider trading will be ever more applicable in those instances, correct? Hopefully you're still with me. Can you hear me, Jason?
Yeah, I think that's right. A little. Your last question broke up a little bit.
Sorry.
But I think what you're saying is absolutely correct. I mean, as we begin to build out more of a digital asset ecosystem, then the idea of trading those assets in any kind of market, whether it's Coinbase, whether it's a foreign market like a Binance or something, you still have to be careful that you're not running afoul of the insider trading laws. So when we get together, for example, when we get together in legal working groups, we always have our disclaimers about how there's no antitrust violations going to occur. We're not going to talk about things like that. But we have to be careful as well about insider information, because if we hear from someone that an exciting new project is coming down the pike, and we know that they've got digital securities or digital tokens that are trading somewhere, and we go out and buy on those digital securities, that could be a violation both of the person who provided the information, violation of a duty to keep that information confidential, and also, of course, a violation from the person who actually did the trading. I mean, even if at the end of the day there is no liability for some reason or other, if you can prove, well, there wasn't actually a duty to keep that information confidential, it was actually publicly known, et cetera, making trades that can invite an SEC investigation is just kind of a bad idea. You don't want to be in a position where, after 3 years of investigation and a jury trial, you're found completely innocent of all charges. That's great, but in the meantime, you've paid a lawyer like me a lot of money to get you to that point.
Yep, absolutely. So I want to pivot back to Telegram a little bit, and I wanted to take a different approach to it. And obviously, you and others have spoken about it at great length. There's this perception for startups and technologists, and some even in financial markets, that when we look at organizations and the Security and Exchange Commission, for example, or we hear talk about the Howey test, there's almost this simplistic, well, SEC needs to change their rules. Rulemaking needs to evolve for the commission. Or Howey test has got to evolve or go away. And I've literally heard this from colleagues at technology startups. It's not that simple. So tell us a little bit.
It is not that simple.
Tell us a little bit about what SEC rulemaking looks like. Tell us why a conversation around a rule that's going back 75 years or so doesn't change that quickly. And I know that there's been some Supreme Court conversations, stare decisis matters that are probably relevant there as well. But let's start at that point.
Sure. So let's start kind of at the beginning of this, which is, if we have a system of rules, the Howey test from that venerable old Supreme Court case, and the case law that's built up around Howey up until right including the Telegram decision. We have an industry that looks at that and says, this is terrible. These are not the right rules. This is bad for our development. It doesn't leave us a path to get from here to there. And by that, I mean from issuing a digital token as a security and then having some time to develop some utility in the system and then offering out the utility tokens. The whole idea of the SAFT model is basically blown apart by Telegram. So it's the Telegram decision. It's left a lot of people wondering, okay, how do we get from here to there? Because right now, Judge Castell's answer is you can't. It's very difficult to envision that. So how do we change that system? Well, there's essentially two ways. One would be SEC rulemaking, as you said, and that starts with the desire at the commission to change the rules, which I don't see right now. We certainly see proposals coming from Commissioner Peirce, who put out a proposal for a 3-year sort of grace period for people to get from here to there, which was specifically targeted at situations like this Telegram situation. But that was one commissioner's proposal, and I haven't seen that it's gone anywhere, and I haven't seen a lot of appetite from Chairman Clayton to try to move forward this kind of rulemaking proposal. Even if there was the appetite, what they would have to do is write the rule. They would release it as a provisional rule, give industry chances to comment on it, so there'd be a window for that. And then they would promulgate a final rule, most likely, that would hopefully incorporate the good ideas that they get from industry and other interested parties. This process can be very, very long. I know that in the waning days of the Obama administration, both SEC and CFTC, following this rulemaking process, were trying to work on rules that were outcroppings of the Dodd-Frank legislation that came out in 2010. So the rulemaking process can be very long, and some of the rules that they were working on never quite made it through before they had a change of leadership in January 2017. So that's one way to do it. The other way to do it is just to overturn the law, just to overturn Howey. But that's also kind of a heavy lift. Howey's a Supreme Court decision, and even though it's old, I mean, as I'm fond of saying, it came out the same year the ENIAC computer was invented. So I'm pretty sure that the drafters of Howey were not thinking about cryptocurrency at the time.
Yeah.
They designed this flexible test, and that test has been with us for the past 75 years. And a lot of cases have followed it up and expanded on it, both at the Supreme Court level, but also in the courts of appeals, the district court. So how do you get that overturned, given that every district court judge who has looked at a cryptocurrency challenge where the SEC or a private party has said, we think this cryptocurrency is a security, every single judge has either said, yes, it is a security, or if it's been a preliminary portion of the case, yes, there's enough allegations or evidence that it is a security that we will consider it as such, at least until it's proven otherwise. So it will continue on in the case. You don't get a case thrown out at an early stage saying we're just a utility token. That's literally never happened. And this is because judges are applying Howey and the progeny of Howey. So to overturn this state of affairs, we'd literally have to overturn Howey. You'd have to have the Supreme Court say, we hear you, we understand that digital currencies, tokens, digital securities, digital assets are a different animal, and they can be considered not securities, and they're outside the Howey regime. But that word needs to come from not a district court or the circuit courts, but from the Supreme Court itself. I mean, this is why I frankly expect the Second Circuit to uphold Judge Castell's decision, because when they examine the same controlling law, they'll come to the same place. So you'd have to overturn a Supreme Court decision, which is difficult. And we've seen recently, I won't go too much into detail about it, but just recently there was a case that dealt with how many jurors it takes to convict someone criminally. Does it have to be unanimous or not? The Supreme Court said it did have to be unanimous. That case had a lengthy discussion amongst several of the Supreme Court justices about stare decisis. What are the factors in overturning a Supreme Court decision? And I think that for the most part, they all agree that the previous decision has to be wrong or egregiously wrong, and it has to be causing a lot of harm, and there can't be so-called reliance interests. That is, there can't be a situation where people have come to rely on that rule. And I think it'd be an uphill battle to get the Supreme Court, as it is currently assembled, to look at Howey and say, well, we think this is just really wrong and causing a lot of damage, and that nobody relies on it anyway. I think all of those points are difficult lifts with the Supreme Court. So I think we're going to be stuck with this regime for a little while longer. And possibly the best hope the industry has is different attitudes and outlook at the SEC. I have no crystal ball on that one.
Yeah, well, it's interesting because we've had this conversation with the commission, and we've had this conversation with members and others in the technology space. And, there's not this adversarial relationship. That doesn't need to be with the commission. The technology companies who are doing these offerings that are willing to approach the commission and their hub, for example, they're happy to have this conversation. This is not, this monolithic commission that's going to decline everything people are doing. They want to they don't want to inhibit innovation, but they have a mission, which is protect investors, for example. So it requires an evolution in the ecosystem.
That's right. That's right. And FinHub has been, I think, a mixed success, if I may. I think they've been successful insofar as it's given the SEC an opportunity to talk to a lot of people, to interact with a lot of people. It's really educated them about the space. So every single time I speak with someone at FinHub or even the enforcement staff who rely on the learning of their colleagues, I find that the SEC has been extremely sophisticated in their understanding of the technology in the space, which I have to say, it has not always been the case with other technological developments. Yep. Where, I think, for example, in algo trading, we saw regulators at SEC and FINRA really playing catch up on the technology and coming to an understanding later than I think the industry might have liked. But with crypto, I think they've learned from that and they're way out ahead, and that's been a very positive development. Where I think FinHub has been less successful, and apologies to my friends at the commission, is they absorb the technology, and very often the result of the conversations is for them to say, okay, thank you very much, go ahead, do what you want, but just make sure you're following all the securities laws. And that's not always the most helpful answer, because if I say, okay, well, we'd like to do that, but we don't see a way to meet this particular rule or this particular regulation with this technological approach, we're kind of met with a not a blank stare, but just a sort of cryptic, well, you just have to follow all of the rules and regulations, which I think is nice, but not entirely helpful. I don't think a lot of people are going hat in hand to the SEC and saying, hey, I would like special dispensations to break the rules. People who want to be rule breakers aren't going to the SEC at all.
Right.
I think the people who are going to FinHub and asking the hard questions are saying there are some places where the securities laws do not neatly overlay crypto rules and regulations and the realities of things. So how can we square these circles? And that's where I think FinHub just doesn't have the authority to be as helpful as I might like. That direction has to come from above, and we're not getting that kind of direction. I think it's been a very frustrating few years for the crypto industry in trying to deal with some of the mixed signals that we see coming from people like Commissioner Peirce or Director Hinman.
Yep.
combined with the lack of movement in any kind of rulemaking or any kind of acknowledgement that the rules may not squarely fit the new technologies.
Yep, absolutely. Important stuff, important conversations. And you and I can have long conversations at some point about no action letters and some technology firms thinking that that's their want, which it is not.
Yeah, I mean, the no action letters that we've seen that have come out have been, for the most part, not particularly helpful in moving the industry ahead. I think they've been important in setting certain boundaries. I think our colleague Lewis Cohen in particular, I'll give him a shout out for doing a great job with one of those. But they're not pushing us ahead as much as a lot of us would like. Absolutely, no disrespect to Lewis on that one, who probably pushed it ahead farther than a lot of people thought could happen.
Absolutely. So we're almost running up on time, Jason. Thank you for this. I do want to leave off with a couple of non-work related things that we bother with. What is it like working from home as an attorney? And every one of our members is binge watching something. What are you binge watching?
Well, working from home, 90% of what I do is talking on the phone, writing briefs, giving legal advice, and that I can do. The 10% that is, going to court and, meeting with witnesses face to face and looking them in the eye and judging what kind of credibility they're going to have, that part's obviously significantly diminished. On the other hand, being at home does give me a little bit more time with the family. I was thinking last year was very, very busy, and I really wanted to spend some more time with the family, maybe have a few more date nights with my wife.
Yep.
All this is not exactly what I had in mind for more time with the family, but I'll look at the silver linings for that.
Yep.
What am I binge watching? Well, I guess we're gonna come full circle and close where we opened with money laundering. I've just finished season 3 of Ozark. So
awesome show.
The son has a lot of holdings in cryptocurrency. So hopefully he's not going to be crossing those streams. Otherwise, he may wind up like our friend Mr. Costanzo.
Exactly. Well, Jason, this is wonderful. Thank you so much for the time. Thank you for being part of the legal working group. We'll leave it there. We'll post this for our members, and then we'll make it publicly available as well. Always a privilege, Jason. Thank you.
Great to talk to you, Ron. Thank you.
Yeah.
Bye now.